India deal, and the acronym, and then tribunals, deference, and state of visa.
You skipped the counterplan in your order?
Oh, sorry, yeah, and counterplan, and then, yeah, sorry about that. Yes, we will be talking about the counterplan. Honestly, my first answer is when we meet nearly every combatant at Guantanamo is suing for habeas corpus claims in the U.S. courts. The test case available is not an issue. And two, there's no abuse, there's no literature and specific test cases after Hamda. They don't lose any ground by not knowing the specific case. And Nexus kills Afghan. The resolution requires us to use the Supreme Court. If we can't run a case specified by the resolution, the negative takes away a quicker Florida of possible ground, and next is no resolution bias. The resolution requires us to use the Supreme Court to overturn expired opinions and specify that we need to use testing. And next is don't vote on official abuses like voting for it, just said we didn't run. And next is counter-interpretation. After we specify what parts of the decision they overrule. And next we meet the counter-interpretation. We rule that every unlawful command be disclassified as lawful, and we commit. And next we prefer the counter-interpretation. Counterplay background. We lose ground to pick out a certain parts that plan overruled. And next is predictability. Since court cases have a limited number of specific claims, the number of F cases is still predictable. And next, don't vote on test case together. There's no round abuse. And next, literature text abuse. And lastly is reasonability. Debatability is all that matters. So don't vote on in theory. Cheap shot. All right, EPA. First, the Supreme Court is likely to rule in favor of the EPA in Massachusetts versus EPA. This came in 2006. The U.S. Court of Appeals ruled against Massachusetts decision that stated the EPA is only required to regulate emissions which can reasonably be anticipated to endanger public health or welfare. And next, given the court's recent decision on wetlands, this is still the same court. Given the court's recent decision on wetlands, it's unlikely that the majority will rule in favor of regulation. And next is ruling against EPA would have serious implications on foreign policy. This was shown in 2006. And an unfavorable decision for the EPA could cause the U.S. to lose its leverage. It currently has to tell other countries they will have non-lower emissions, but other countries do not. It's not up to the courts or the states to challenge the direction of foreign policy. And even if the Supreme Court rules against the states in the EPA versus Massachusetts, the court will galvanize the movement towards CO2 regulation. This is inside Green Business in 2006. The Supreme Court could intensify political pressure over the carbon dioxide emission controls. Even the High Court upholds the federal government's claims that it has no statutory obligation to address climate change both industry and environmental sources say that even a model court ruling, even affirmative federal government's opposition to the regulatory CO2 limits made only intensify calls for congressional action in current global warming. Industries observers say groups oppress the CO2 rules that have more to lose in environments and other support of the CO2 from the court's decision to hear the case. If they lose, they are where they are. And ruling against the states would give the environmental groups greater reason to petition for Congress for CO2 controls. This is the Inside Business Weekly report in 2006. The higher court ruling will be galvanizing no matter what way around the EPA will proceed, and the issue will be before Congress. Even the high court, where the environmental groups ever supports EPA regulation on CO2 components, CO2 returns will have further reason to petition Congress. And the issue is the Supreme Court will address the EPA versus Massachusetts and not global warming. The EPA's interpretation of statutory language was briefed in 2006. The groups are focusing on their decision in the lower court's decision life allowed us to handle all federal agencies and certain statutory requirements that will end. Sources from the appeals of the petition are seeking to raise the issues in the court by emphasizing the out-of-place decision impact on broad agency interpretation of statutory language. The ruling in this case is the extreme court's precedent on statutory interpretation. EPA rewrote the Clean Air Act despite the decision opinion from improve this right to allow the decision standing up to be seen in the normative power administrative agency directing language dismantle statutory regimes that will simply do not like India deal. Oh wait, sorry. Back to EP for a minute. And the impact here is just never going to outweigh the case. We have the distinction impact on difference is always going to come first. Then this big biodiversity impact that has no time frame. All right, India deal. There's no India deal by opposition and not enough time to get it through it. The lame duck. There's this energy Washington week, November 8th. The deal was momentum opposition common. The student version remains stalled over current disagreement. Each side blaming the other for not passing and racism in the near-term prison. Side Democrats have blocked unanimous consent on the bill because the desire to add amendments, blaming Republicans for blocking attempt to bring the measure to vote. The facts of the Republicans' differences are the summers of the bill have delayed in Congress consideration on the judiciary are still not resolved. Still not understood whether these should be resolved during the language. Far more likely the bill will be resolved during the next session of Congress. And India deal won't pass in the lame duck. Not enough time. Not high enough for it. This statement November 6th. The midterm elections in the U.S. Tuesday will not be crucial for the American cause, but also for the future of the India-U.S. nuclear deal. Will only take for the Senate vote to be introduced in 15 November in the lame duck. There's also a concern that there might not be enough time for a joint Congress to be held and the final bill to be created before the 109th Congress ends before mid-December. Analysts now increasingly see some terms of navigating messaging and completing its course in Congress this year. We're seeing it will be passed only in 2007, but there are several improvements to the bill to reach this and not least the heavy schedule of domestic legislation, including 10 appropriation bills and bipartisan tax package, which is why White House President the bill is given temporary. It gives only its second bill to normalize relations with Vietnam. And the India deal won't pass the lame duck because there's too much stuff other stuff in the way. This is Washington Times, November 4th, which has been pushing the Senate to make other measures during the brief land tax session. The lawmakers must also deal with panel after spending bills in the land tax session. Not clear if there will be room on the panel for all the business chooses voting for the message turnover in either chamber, especially Democrats that could wage against supporters in the India pact. Pact for the land tax session will be unlikely to take major legislation in India and nuclear deal. Okay, that's fine. Activism. First, judicial legitimacy is low trust in the courts that is faltering. Karnowski and 2006. Senator Joe Kennedy said the Senate to make a potential attacks of judicial independence in each and every year. Some of the judges run amok judicial activism surrounding recent years. Critics of the court have called for cutting and stripping of their jurisdiction. Parliament made so careful to ensure independence of the federal judiciary. These concerns are very real today, and Turing classified the non-evidence from solvency deference had made the U.S. government look illegitimate. Only shutting undue deference can restore court legitimacy, and Turing court inaction destroys legitimacy at home and abroad. This is Waters in 2005. U.S. courts refusal of participating in judicial actors also caused serious conflict with the rules and international norm legislation. Just as non-participated by U.S. courts empowers domestic judicial justice to make investment powers in the international legal discourse. Non-participating in U.S. courts greatly decreases the likelihood of the U.S. norm to influence the international legal norms on the government issue. Early and active involvement in the judicial dialogue and political coalition, for example, can ensure that a domestic court's interpretation of a given norm will become the dominant standard. And no link citing international norms to interpret the law has precedent as Human Rights Watch, June 2003. On June 26, 2003, the U.S. Supreme Court ruled in going for the constitutional right to privacy checks the consensual allosexual intimacy in the home, declaring Texas homosexual conduct law and constitution of the court, overturned the 1986 Supreme Court decision in Broward versus Republic of Health State was making homosexual sex a criminal offense. The amicus brief argues that the principles of privacy and equal protection being examined by the court should be interpreted by the light of the rulings of the foreign and international courts of nations with similar history, legal system, and political courts. The weight of international foreign court authority establishes the sexual conduct between the same-sex partners involves precisely the same kind of decision-making familiar with the relationship counterclaim. My first argument is that this has absolutely no solvency mechanism. There's no long-term solvency to the sort of advantages that we are talking about here. It's just they're not taking away presidential powers or getting rid of this lawful and unlawful distinction that is causing so many problems. They're just saying that the president can't do it right now in the status quo. That does not in any way prevent him from doing it at any time in the future. As soon as Congress declares war, the way they're not reading you any evidence about Congress not declaring war, as long as they have the ability to do that, and then the president will have those powers once that eventuality occurs, you're never going to be able to capture any of solvency. And if anything, they just might get some sort of time period advantage by saying that we're stopping it in the status quo, but the impacts are always going to outweigh this. And Nexus links to all their disadvantages because they're all court actor disadvantages, and the fact that they're still using the court is just going to link to them just as much. So there's no net benefit here. You're going to always go on the risk of ending the ability of the state to, of the president to make the state of exception, and also there is, okay. Do you have my stuff? Military tribunals?
That's this.
First, no, like the plan text doesn't say we use military tribunals. There's absolutely no evidence indicating the military tribunals will not solve the mechanism. And non-unique enemy commands are already attempting to use military tribunals. In CNN 2005, it's slated for the military tribunal under the U.S., which has been appealing the appearance before a tribunal. All of this resolves around the question of the legal rights that detainees and so-called enemy commands, which is what the Bush administration has designed them as versus the designated prisoners of war under the Geneva Convention. And also the Give card on this advantage is always going to outweigh this nuclear terrorism impact. There's just no deference. Okay, well then, first of all, the Honda argument that just because that already happened, that is not enough of a step to actually cause these impacts, and we're always going to outweigh. This is I mean, if anything, this is our brink argument. And on the military readiness, our deference extinction scenario is always going to outweigh this because it's a more specific scenario, and I mean, they're just not very good cards. State of exception.
Here's the renditions answer.
Where does this come?
It's his answer to renditions.
On what?
On state of exception.
Okay. Habeas corpus claims to prevent extraordinary renditions of the Amnesty International May 13th. However, just to implement the rule in 1997, the government's declaration concerning general policy practices to remedy claims or render them frivolous. Okay, I'll mark it. And also, this is all answered by the Michelson card that we have to reject. We have a responsibility to reject the ability of the state to render the state of exception in the status quo. And I mean.
All right. Aren't all of your advantages predicated on the violence ongoing in the status quo?
Yes.
Like in Guantanamo?
I never read
and isn't your SOE stuff, isn't that all specific? Like, isn't the Agamben authors you're reading all specific to the state of exception that exists in Guantanamo?
Yes, but it's the problem. The fundamental problem is that the law allows the state of exception to occur. Yes.
But
So if you aren't not allowing that to occur, like it's still going to. I mean, you're going to have it sometime in the future. We might be able to stop the harms in the status quo, but the underpinning problems won't be solved, and you're just opening the door for it to happen somewhere down the road.
So what you're saying is, so we're allowing it to happen in the future, like possibly in the future when Congress declares a war.
Yes.
Okay. Now the answers on judicial activism, like how does the court's legitimacy at home, like to individuals, like its citizens, and to people abroad, how does that interact with like the three co-equal branches, the executive, legislative, and Supreme Court?
Court legitimacy is essentially the
Like just because they look
opposite
legit
of activism.
I thought restraintism was the opposite of activism. Like, isn't not telling other branches what to do restraint?
Yes. Well, I mean, the cards that are specific to the legitimacy are talking about legitimacy in opposition to activism, and they're just essentially non-unique.
Okay. Now on the SOE position, what is your answer to rendition? I mean, if we're just going to send all of these people to somewhere else and torture them and create a state of exception somewhere else, how do you solve for that?
Well, we get rid of the ability of the president to create the state of exception, so when that happens, they won't be allowed to.
I understand you get rid of the ability for him to make the illegal lawful distinction, but how do you get rid of his ability to render, which is just to straight up have the CIA hide him out somewhere and under the jurisdiction of another country to be tortured there? What are you doing about that?
It would be answered back by the deference advantage, just by like restricting his power. He won't anymore have the ability to just do whatever he wants with people he captures or people he arrests.
So he'll just get the signal from the courts. There is no like real structural enforcement. He'll just be like, yeah, the courts probably don't like me abusing my power. That's just.
Thank you. Did you read this